Welcome to the Deep Dive. Today we're tackling a story that's, well, truly shaken communities across Australia. I'm talking about the recent childcare abuse scandal in Victoria involving Joshua Dale Brown. The details are horrific. Over 70 criminal charges, sexual penetration of a child, victims apparently as young as 5 months old, allegations spanning 2022 into early 2023.
It's deeply distressing stuff.
Absolutely. And it sparked this firestorm of public outrage. You've got Victorian Premier Jacinta Allen calling the allegations sickening.
Understandably so.
And media figures labeling it a failure of the entire system. But, these headlines, as vital as they are, they really only scratch the surface, don't they?
They do. There are huge institutional and legal questions bubbling underneath.
So let's unpack this. Our mission in this deep dive isn't just to rehash the shock or the criminal charges. We want to focus on the employment law side of things, the workplace responsibility angle.
Yeah.
Because what's fascinating here isn't only the alleged individual crimes, but the kind of uncomfortable questions this raises for literally every workplace in Australia.
Particularly those involving vulnerable people, yes.
Right.
And this isn't just, a single criminal case. It feels like a moment of national reckoning. It's a critical case study in systemic failure, especially when you look at it through an employment law lens.
It really highlights vulnerabilities, doesn't it? Things employers might not even realize exist in their own setup.
Precisely. Blind spots.
So whether you're listening as an employee, trying to figure out your rights, or maybe you're an employer grappling with your duties.
Or just someone concerned about workplace safety generally.
Understanding these principles is absolutely crucial. It's how we can spot those blind spots, hopefully prevent future harm, and ensure, real accountability.
Yeah, getting clarity on those often overlooked legal duties.
So this deep dive aims to shed light on that, bringing some clarity to what feels like a very murky situation. Okay, let's get into the heart of it. The story starts as a criminal investigation, obviously, but the source material we're looking at really reframes it. It talks about a devastating example of systemic workplace failure.
Yes, that's the shift in perspective.
And here's a detail that just screams systems issue. Joshua Dale Brown reportedly worked across, over 20 childcare centers in Melbourne? Over 5 years.
That's the report, yes. Over 20 centers.
Yet the confirmed offenses, right now anyway, seem linked to one specific center, Creative Garden Early Learning in Point Cook. That alone just throws up massive red flags about employer processes, doesn't it?
It absolutely does. The immediate question is just how? How does someone move between that many centers without triggering deeper background checks?
Yeah.
Or, consistent alarms somewhere? And the source really stresses this point. This wasn't necessarily just a predator slipping through the cracks, as awful as that is.
Yeah.
It points towards an employer potentially failing to act, failing to supervise.
Failing to protect.
Failing to protect, exactly. It suggests issues like poor governance, maybe inadequate training, neglecting basic workplace rights. It's a dangerous mix.
A combination that could create fertile ground for abuse.
Potentially, yes.
And it makes you think about those questions, the ones beyond the headlines, that every employer should probably be asking themselves right now.
Like what?
Well, the source highlights things like, where were the policies and procedures? Crucially, were they actually followed?
That's a big one, the follow-through.
And were concerns raised by staff? If they were they ignored?
Or worse.
Worse, was there a failure to act lawfully? These aren't just, hypothetical questions, are they?
Not at all. They go right to the core of workplace law and compliance. They shift the focus from just condemning one person's alleged actions to really scrutinizing the environment that might have allowed those actions to fester, allegedly. From an employment law standpoint, these are potentially devastating lines of inquiry in court or before the Fair Work Commission.
Exposing potential negligence?
Serious negligence, yes, on the part of the employer.
Okay, so if these questions hit the heart of the law, what about the employer's actual duty? Because safe workplace can mean different things. Lots of people still think physical safety, right?
Yeah.
Wet floors, trip hazards.
Yeah, the traditional view. Hard hats and high-vis vests.
But the law goes much, much deeper now.
It does. And here's the real eye-opener for many. Workplace safety isn't just about physical hazards. Of course, that's part of it.
Sure.
But the legal duty, under both work health and safety laws and the Fair Work Act 2009, it extends much further. It absolutely includes protecting staff and clients from psychological harm, from trauma, emotional distress.
Wow, so that shift from physical to psychological duty is huge.
It's the game changer. especially, as you said, in high-trust sectors like early childhood education. The vulnerability of the children, the trust placed in caregivers, it just amplifies everything.
That's a critical distinction. It's not just avoiding slips and falls. It's about an environment that's genuinely safe emotionally and psychologically.
Yes.
And the source mentions this positive duty to act if concerns are raised. So let's say, hypothetically, Brown's coworkers saw something inappropriate or they had concerns, suspected something wasn't right.
And they reported it.
Right, they reported up the chain, and if those concerns weren't acted upon,
Then the employer may well have breached that positive duty, directly breached it.
and the consequences of that breach, what are we talking about?
Significant legal exposure. It's not just, bad management. Employers can be held vicariously liable for what their staff do.
Okay, explain vicarious liability a bit more.
Think of it like this. Even if the employer, the company itself, didn't directly do the wrong thing, they can still be held legally responsible for their employees' actions if they failed to take reasonable steps to prevent the harm from happening in the first place.
So what are reasonable steps?
Well, things like ensuring proper supervision, having HR processes that actually work, that are responsive.
Not just ticking boxes.
Exactly. And fostering a culture where people feel safe raising concerns, knowing they'll be heard and followed through with actual decisive action.
Right. A court would basically ask, you were told something might be wrong. What did you do about it?
Precisely. And if the answer is nothing or not enough, the consequences can be severe. We're talking significant financial penalties, reputational ruin that's almost impossible to recover from.
Loss of operating licenses, potentially.
Absolutely. The impact is devastating, not just for the victims, obviously, but for the entire organization.
And a massive part of creating that safe culture where concerns are acted on has to be protecting the people who speak up. The whistleblowers.
They're often the first line of defense, aren't they? The eyes and ears on the ground.
Totally. And Australian law is designed to shield them.
It is. And this connects to the bigger picture of fundamental workplace rights. The general protections under the Fair Work Act 2009 are specifically there to shield employees from what's called adverse action when they exercise a workplace right.
Okay, adverse action and workplace right. What do those mean here?
A workplace right includes things like making a complaint or inquiry about your employment. So making a complaint about unsafe conduct or unlawful behavior or breaches of policy that definitely falls under exercising a workplace right.
Okay.
And adverse action is when the employer punishes the employee for exercising that right. It could be dismissal, injuring them in their employment, altering their position to their detriment, or discriminating against them.
So these general protections are vital. Without them, people would just stay silent.
Exactly. Serious issues could just fester in the dark because people are too afraid to speak up for fear of reprisal.
So, if an employee raises a legitimate concern, what kind of negative treatment counts as unlawful retaliation or this adverse action? The source gave some examples.
It did. And it's important to realize it's not always outright dismissal, though it can be. Retaliation can be more subtle.
Like what?
Like an employee suddenly giving fewer shifts, or maybe being transferred to another center inconveniently, or just being treated coldly by management, iced out.
Sidelined from duties.
Sidelined from duties, yes.
Yeah.
All these things could be adverse action if you can link them back to the employee making that complaint or raising that concern.
That's retaliation, plain and simple. And the source is crystal clear. It's not just bad practice or unethical. It's illegal.
Absolutely.
An employer might have a glossy policy saying, we support a speak-up culture, but that policy is completely worthless if the people who actually raise the alarm get punished.
It undermines the entire system.
And employers who do that, who punish the whistleblower instead of acting on the warning, they face serious penalties, big compensation orders, public scrutiny, massive reputational damage.
The message from the law is stark. You cannot shoot the messenger. Doing so breaks trust and fails everyone.
Now, here's something that often catches people out, especially in cases that seem so awful, so clear-cut. Procedural fairness.
Yes, the process.
You might think, look, the allegations are horrific, just get rid of the person, why bother with procedure? But the Fair Work Commission doesn't just look at why someone was dismissed.
No, they look very closely at how it was handled.
So why? Why are these, as the source calls them, tick-box formalities, so critical even when the accusations are this serious?
Because they uphold a fundamental legal principle called natural justice. It's the basic right for someone to be heard, for a decision about them to be made fairly and without bias. And the source points to Section 387 of the Fair Work Act. This says that even a dismissal for serious misconduct, which these allegations certainly would be if proven, can still be found harsh, unjust, or unreasonable if the process itself was flawed.
So rushing to fire someone to protect the company's reputation without following due process.
It can backfire spectacularly.
Mm-hmm.
You could end up facing compensation orders, paying hefty legal fees, maybe even being ordered to reinstate the employee.
Even if the original allegations were true.
Even if the allegations were true. If the process was fundamentally unfair, the dismissal itself can be ruled unlawful.
Yeah.
It's a very costly lesson in why you cannot cut corners.
A crucial point, especially when employers are in panic mode. So what are these minimum standards? What's the playbook for a lawful termination to ensure that procedural fairness?
Well, there are several key steps. First, the employer usually needs to suspend the employee appropriately, often with pay, while a proper investigation happens.
Okay. Suspend, then investigate.
Then the specific allegations must be put to the employee clearly in writing. No vagueness.
Got it.
The employee must then be given a genuine opportunity to respond to those allegations. And their response has to be genuinely considered, not just dismissed out of hand.
Makes sense. What else?
A fair and impartial investigation needs to be conducted, someone unbiased, looking at the facts.
Right.
And critically, the employee must be offered the right to have a support person present at any meeting where these serious allegations or the potential dismissal are discussed.
Okay, so suspension, written allegations, chance to respond, fair investigation, support person. Those are the foundations.
They are, and neglecting even one of those can derail the whole process legally, no matter how severe the alleged misconduct might seem.
Which means, let's imagine a staff member from one of those centers Brown worked at comes forward. They say, I tried to raise concerns, but I was ignored or maybe even pushed out. What would the Fair Work Commission look at then?
Well, their focus would broaden considerably beyond just the allegations against Brown himself.
How?
If we connect this to the bigger picture, the commission would meticulously examine how the employer responded to those internal concerns. They'd scrutinize whether all the proper legal and procedural steps were followed regarding that employee who spoke up.
So they'd be asking things like,
They'd ask, what exactly was reported? When was it reported? Did the employer actually follow its own policies for handling complaints or misconduct? How was that policy applied?
and crucially,
Was any adverse action taken against the person who raised the concern? Were their hours cut? Were they demoted, transferred, isolated, or ultimately terminated?
and if they were terminated.
Was that dismissal handled lawfully? Was there procedural fairness, written notice, chance to respond, support, all those things we just discussed? Every single step, every management decision regarding that whistleblower would be under intense scrutiny.
So it really reinforces that point. It's not just about the reason for dismissal, but absolutely the manner of it. The source really hammers this home. It says, even if the employer had a legitimate reason to terminate the accused worker, they could still lose the case if the process was flawed.
That's the crux of it.
And it concludes, in every high-stakes workplace issue, process is everything.
Yeah.
You just cannot skip it and expect to be legally safe no matter how bad the situation looks on the surface.
Process protects everyone, ultimately. It ensures fairness.
Now, this whole tragic scandal has, understandably, caused massive public reaction. Shock, outrage, disbelief,
A huge outcry.
and urgent calls for accountability, for systemic reform. We've even seen some voices online suggesting maybe in the heat of the moment, banning men from working in childcare altogether.
That's come up. And while you can understand the visceral reaction, the fear and anger driving that,
It's not the answer.
no. The expert consensus reflected in the source material is clear. The problem isn't gender. It's broken systems. It's weak policies, poor vetting, inadequate training, and crucially, poor employer responses when concerns are raised.
Right. Scapegoating a whole group does nothing to fix the underlying failures.
In fact, it could distract from the real issues that need addressing to actually create safer environment.
Yeah.
We need to focus on what works.
Exactly. So moving beyond blame, what are the key practical reforms that experts are saying we genuinely need? What would actually help prevent future tragedies like this?
The source outlines several critical changes. First, moving beyond simple background checks. There's a call for mandatory prevention education as part of all BEAD want, working with children checks, not just screening out, but actively educating in.
Okay, proactive education. What else?
Truly proper vetting processes during recruitment, going beyond basic checks to do deeper background analysis, maybe character assessments, Really checking references thoroughly.
Not just box ticking.
Definitely not.
Then,
Establishing HR systems that are trauma-informed. Systems designed to respond quickly, empathetically, and effectively when concerns are raised.
right.
Making sure staff who come forward feel supported, not dismissed or re-traumatized.
That sounds crucial.
And perhaps the most fundamental piece, fostering a genuine workplace culture where staff feel safe, even encouraged, to speak up without any fear of reprisal, where transparency is valued over protecting reputation at all costs.
Yeah. What's really striking here is that clear message. When employers prioritize reputation over people, when they choose silence or defensiveness over transparency and action,
The public won't stay silent.
and neither will the law. This crisis has shown such a bright, uncomfortable light on those institutional failures. It shows it's often the broken systems, not just individual actions, that create these awful vulnerabilities.
A system-wide issue demanding a system-wide response.
So as we wrap up this deep dive, let's quickly recap the core message here. This terrible scandal really underscores the absolutely critical role of employer legal duties. Things like the duty of care,
Including psychological safety,
robust whistleblower protection,
so people feel safe speaking up.
and unwavering procedural fairness, even in the toughest cases. These aren't just legal niceties, are they?
No, they're the bedrock, the foundation of safety and accountability, especially in high-trust environments like childcare, but really in all workplaces.
It's a potent reminder.
And looking at the broader implications, maybe the sobering question this forces us all to consider is this. In our own workplaces, do the policies we have actually protect people? Or are they just, performative documents gathering dust on a shelf?
That's a heavy question.
What hidden failures might be festering right now if staff don't feel genuinely safe raising concerns? If they fear retaliation more than they trust the system to protect them?
So, what does this all mean for you, listening? It's a stark reminder, isn't it? That real safety, real accountability, it comes from constant vigilance. It comes from building a genuine culture of listening.
And a commitment to not just having policies, but actually living them, day in, day out.
Definitely. Maybe consider what role you could play in fostering that kind of culture, whether you're an employee, an employer, or just a concerned member of the community. It's a vital conversation and one that absolutely needs to continue long after these specific headlines fade.